Hey, my federal workforce fam. Remember the shadow docket order in McMahon versus New York, the DOE case that we talked about? Well, I want to dive a little deeper into it because you need to understand how this shadow docket order may just be a preview of what's to come. So as we discussed, the Supreme Court handed down an order letting the Department of Education continue its mass layoffs while the larger case continues to work its way through the courts. Now, I have said this before, and I will keep saying it because I need you to hear it loud and clear. This isn't the final word on whether these RIFs are legal, but it is a big signal about how this court is going to handle these cases in the short term. So here's what happened. In a one-paragraph shadow docket order, unsigned and unexplained, the court lifted a lower court injunction that had reinstated 1,378 DOE employees who were fired earlier this year. No reasoning, just silence. But the liberal justices on the court were not having that silence. Justice Sotomayor, joined by Justice Kagan and Justice Jackson, filed a 19-page dissent that reads like a warning shot for the future. Justice Sotomayor called out what's really at stake, that the president cannot unilaterally dismantle federal agencies by firing everyone who makes them function. Her words were sharp. This move, she said, hands the executive powers to repeal statutes by firing all those necessary to carry them out. That is separation of powers 101, folks. Only Congress can create or abolish agencies. The president's role is to enforce the law, not erase it via pink slip. She also pointed out that the department's core mission, student aid, civil rights, special education, is being gutted in this process. And it's not hypothetical. This is real harm happening in real time to programs that millions rely on. So here's why her dissent matters. While the majority is staying silent, the dissent is laying out a legal roadmap for the challenges ahead. When the RIF cases come back on their merits, Justice Sotomayor's framing of the issue about constitutional limits on executive power could shape how the lower courts and possibly even the Supreme Court later rule on the legality of these mass federal layoffs. So for my federal employee friends, let's break this down. Number one, if you are DOE and you are among those reinstated by the district court, you're back in limbo for now. Off the payroll, but waiting for your day in court. Number two, other agencies watching just got a soft green light to keep moving forward with their RIF plans. But remember, this court hasn't said those plans are lawful. They're just letting them proceed for now. Number three, the dissent underscores that there are serious legal arguments against these mass layoffs that haven't yet been decided. So here's what I want you to take away that I'm going to keep saying again and again and again. This fight is far from over, guys. The Supreme Court's conservative majority seems comfortable with letting the cuts happen first and sorting the legalities out later. But this scathing liberal dissent gives us a foundation to keep these challenges and actions to protect the civil service. So stay vigilant, stay connected. Know that we're keeping our eyes on every development so that we can stay in this fight with you and keep you informed step by step.